Good morning, Your Honor. For the record, afternoon, Salem Saman appearing on behalf of and with Mr. Schultz sitting in my office.
All right. And you are?
Ken Olson, Your Honor.
Courtney is not here.
No, she is not.
All right. All right. Where are we on this case?
Well, Your Honor, the last time we appeared for the pretrial, I think the only thing that Mr. Olson said was he didn't agree with the amount of rent that was owed. I have sent to the court an exhibit. I emailed it a couple of days ago that references the amount that is owed. There is December, only 25 out of the 52 was paid, so there's 2,700 left for December. Then you got January 5,200, February 5,200, which is 13,100 plus 1,275 in late fees, brings the amount that's owed to 14,375.
Late fees are how much?
$25 a day, Judge.
That's illegal. That's liquidated damages. That you can't charge $25 a day late fee. Late fees have to be reasonably calculated on a rental property. They have to be reasonably associated with what it would cost for the collection of one's rent. $25 a day is not it.
Well, that's the understanding, the agreement between the parties, Judge.
Okay, but you know, counsel, people
I do
cannot agree
understand.
to illegal, they can't agree to illegal things. And nor will the courts enforce illegal things.
Okay.
Sir, have you seen this? This exhibit?
What is, I don't, I'm sorry, I didn't.
No, it's okay.
Okay, yeah, that's the first me seeing it, but yeah, yes.
Pardon?
Yeah, I didn't, that's the first me seeing that. All it is on the paper that was sent to me to come here was the 7,900 plus late fees is what was on there.
Okay, but part of your dispute was that the amount was not correct.
Yes, that's what, during the Zoom meeting last Friday, yes.
Okay. So when you look at this document I just shown you, do you still hold that position that this is not a correct amount?
Without the late fees, yes. I mean, I know what I owe.
So you would agree that the $13,100 is owed?
If that's without late fees, yes.
Yes, that's the $2,700 for December and then $5,200 for January and February.
Correct.
All right. Were you going to pay this amount or what were you?
My intention is to stay in home and pay the amount owed. I just was kind of, again, when the money came out last week, what was told last week with all the late fees, I was really confused. And so my intentions are to pay the money.
When are you going to pay it? Let me ask you, I'll put it to you this way. If it's 13 without the late fees, 13,100. When is your plan to pay that?
In the next few weeks.
When you say in the next few weeks, what date are you talking about? Because
before March 1st.
Well, you understand that it's the 20th today.
I understand. It's been a rough start of the year. Money's owed to me, and
I know, I hear.
So
You're telling me because you said the next couple weeks.
correct.
In the next couple of weeks, I will be into March, but then you told me I pay it before March. I don't know what you're telling me. Two different things.
I understand. I'm gonna need a few weeks, at least 2 weeks. I can
But
pay.
then, if you have 2 weeks, there's going to be another $5,200.
Correct.
So are you planning on paying that amount too?
I have to have a place to live. It's not just
Oh,
myself.
I understand that, sir.
Okay.
Answer my question.
Yes, I plan to pay, to the best of my ability, I plan to pay the money owed. I've never been in a situation, I apologize, so, but I plan to pay the money owed, or I'm gonna have to vacate the premises. It's one of the two things. I understand this. It's just been in a rough spot.
So I can do one or two things, counsel. Well, I don't think there's a dispute as to the 13,100. I'd grant you, I'm not enforcing the late fee provision because it's not a proper late on this account. So if it's 13,100 plus your cost, and I have your cost, I have cost in the amount of $295. So you say you can have it in 2 weeks?
Yes,
Here's what I'm gonna do. We're gonna find after hearing that there's no tribal issue as to at least a portion of this. I will grant a judgment to the plaintiff in the amount of $13,100 plus their cost of $295.
Tenant loses on the rent, wins on the late fees. This is classic courtroom balancing. Enforce what's valid, strike what's excessive. But here's the pressure point. Now the tenant has 10 days to come up with over $13,000. Be honest, how many people can realistically do that?
Which would be a total amount of 13,395. Specifically, I'm indicating I'm not enforcing the late fees provision. I grant this judgment today. 10 days out is going to be March 2nd. And sir, what day I'm granting the judgment today, 10 days out. March 2nd would be the 10-day period. Are you gonna have this paid by March 2nd?
that is the plan, Your Honor.
With the writ to issue March 2nd, or 10 days from the date of signing? That judgment then does not include March rent. You guys have to figure that out. All right, submit a judgment to the court. I'll sign off on it.
Good judge.
Thank you. Court calls the case, Kyler Johnson versus Amadalyn Bailey.
Ready, Your Honor. Dawn Van Dusen, P69647 on behalf of plaintiff.
Judge Dominic Camden, P67745, appearing on behalf of the defendant, Amadalyn Bailey. Judge, my client is also in the Zoom room.
Oh, there she is. All right, where are we on this case, folks?
Your Honor, this matter that it's regarding a trailer park, a mobile home in that park. My client, which is Kyler Johnson, owns the trailer in the park. Miss Bailey is his ex-girlfriend who is occupying it at this time. At this time, they did do a purchase agreement at one point, but I think I don't know where they got their purchase agreement, but Mr. Johnson would like to, already told her that he was going to rescind it. He does not live there at this time, but he would like the occupancy to happen. He has a loan payment on this trailer each month that has never, it was agreed that she'd split half of it. She still hasn't made any of that. She failed to make payments October all the way to February on just that loan, which is her portion would be 500 of it. But with them not being together, it's a total of 1,000. The rent there on the lot,
Because they're not together, her payment went up.
well, they agreed they would split it at one point, but she hasn't made any of it. So we're not even asking for a judgment in this matter. We just want, as in a money judgment, we'd just like Miss Bailey to move out of the home, out of the trailer. She's changed the utilities into his name, into her own name. She has, so he cannot even get access to make sure payments are made. So she's actually only made payments starting in January for the utilities. So we're asking at this time that eviction of a 10-day order be granted to order her out of the premises.
Mr. Hamden.
Judge, the parties are subject to a purchase agreement. I don't believe you can just unilaterally rescind an agreement. I don't believe the purchase agreement provides for that. And my client is still wishing and desiring to go forward with that purchase. Second of all, my client is on the written lease agreement with the park. And so she has the right to occupy this space as the landlord to the property. So this is probably better characterized, Judge, as some form of a replevin case, as opposed to an eviction in order to retain his property back. It's not properly characterized as an eviction. It's probably better characterized as some form of a replevin.
Well, but I don't. Is the purchase agreement still in effect?
It
No,
did not
Your
have
Honor.
it did not have a termination date, Judge.
Your Honor, it also says the initial payment is non-refundable. It looks like she received this piece of purchase agreement, a copy of it, and that she filled it out, and it was part of the parks where if they were going to sell you one of their trailers. I mean, there was no down payment. There's no initial payment that it discusses is non-refundable unless the applicants are denied their credit and background check. Your Honor, this is not a normal purchase agreement, and it has no closing date, no nothing on it. My client has rescinded 2 days after he signed it and said he does not want to sell it to her.
And again, my comment on that, Your Honor, would be that my client was prepared to close on it, had coordinated with a lender in order to do so, and he refused to go forward with the closing, and there is no provision in there which allows him to unilaterally rescind it.
We went from landlord-tenant dispute to potential domestic violence implications. Judges tread extremely carefully here. Courts do not want to evict someone who may be a victim. This is where property law collides with public policy and emotions run high.
I think it's also worth noting, Judge, that the parties, and I'm sure Your Honor has put 1 and 2 together, at one point in time dated each other. And one of them was required to leave the premises because of a police report. And so what this appears to be is
Oh, dear God. Is that true?
Your Honor,
Hold on a second. No, I just need a very clear answer because this court has a very clear policy on that. And I'm just going to say, because usually it's the male that's doing this. Is there a domestic violence complaint that was made?
Yes, Your Honor, it was made on October
And
23rd.
he was then required to leave the premises?
Correct.
I am not.
And Your Honor, there's no charges pending against my client. In fact, the charges were dismissed by Miss Bailey 2 days later after she made the complaint.
Okay. How long were they living together?
That would be something that my client would have to answer, Your Honor.
Judge,
Miss Bailey, how
We were-
long?
Living together 1 year.
Okay. All right.
Your Honor, I wanted to add something. I just wanted to say that the reason why of wanting to go back on the purchase agreement was because initially I had signed the purchase agreement, and the next day she was trying to falsely accuse me of, and call the cops on me for stuff that wasn't done, and just falsely accuse me. So that was
So
why
you
I
got
wanted to
mad
go.
and said, I'm rescinding the purchase agreement, blah, 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 blah. I hear it all. All right. So what do you guys want me to do? I am not issuing a judgment, not today. And I'm assuming, Mr. Hamden, you want to file a written answer to this.
I do, Your Honor, and I think it would be helpful if the court actually saw the purchase agreement, as well as the lease
Well,
agreement.
somebody attach it, because if the
I'll-
purchase agreement's there, but there's also another signed document between the parties, correct?
There's a purchase agreement that was signed between the parties, Judge. The other agreement was signed with the park landlord, to which my client is a tenant, as well as Mr. Johnson. They are both tenants from the park landlord standpoint. I will attach both of those to my written answer.
So yeah, that was going to be my next question. So under what theory is the plaintiff terminating the tenancy?
Eviction, he owns the mobile home that she is living in at this time. He owns the mobile home. He actually has a mobile home mortgage that he has to pay every month. On top of that, then they rent the property the mobile home is on. So the only thing they have a lease for is the property that the mobile home is on with that park. So all he has to do, and which he has already started doing, and is he has to go in and get her off the lease, which means he just has to do
You know,
brand new,
if I wanted to do a family court and deal with a divorce, that's not really a divorce, I would have done that. I don't know why I'm even dealing with this mess.
because it's an eviction, Your Honor.
I don't know that it's a proper eviction, because I've got a purchase agreement for property that one is saying I got mad and I just rescinded it after I signed it. The other party is saying, well, I'm sitting in here and he's gonna, I mean,
Yeah, the terms of this purchase agreement haven't even been fulfilled by her. She's already, at the beginning, she was supposed to give him initial payment, and that has never been done. So the terms of this purchase agreement are
yeah,
so
but your
vague.
client just said that's not the reason why he wants to rescind it. He wants to rescind it because he got mad because she was saying things. He just
Your
said
Honor.
that to me.
Yeah, she has not even made in good faith an attempt to go try to finance this trailer.
My client had it financed, Your Honor, and was prepared to close. And I'm looking at the purchase agreement, and I could be wrong, and I
Here's the
don't
thing.
want to be held out.
You
Judge.
can
There's-
keep talking.
there's
I don't
nothing
really
in here.
care.
I was gonna say,
I don't really care, because if there's a purchase agreement, you're saying that she's not doing whatever. And okay, fine. But your client just told me that's not the reason why he rescinded. I mean, counsel, I'm just going to let you know, because if there was a domestic violence accusation, this court has been very consistent with its files. With a police report filed, whether it's carried through or not, the court is going to be very reluctant to evict someone who may have been a victim of domestic violence.
That's a policy statement, and it's powerful. Even if charges are dropped, the existence of a report changes the equation. The judge is signaling, I will not be used to weaponize eviction. Now the strategic question becomes, is this truly about unpaid obligations, or is this fallout from a broken relationship?
I
And
understand,
I'm getting,
Your Honor,
I'm getting,
but it is-
I'm getting the sense that that's the reason why the purchase agreement didn't go forth. That's the reason why everything is now being sort of couched as this eviction and this is my property.
But Your Honor, this could also be a reason how she gets him out of the home. She knows if she calls the police, makes false allegations, that he has to leave the premises. There's a reason it got dismissed 2 days later.
Well, you said she did it.
Well, she did. She went and, she made the allegations to get him out of the house. When he said, well, I'm not going to sell you this property anymore, then she says, I'm going to go dismiss the charges.
Mr. Hampton, how long do you need to answer?
Monday, Judge?
Pardon?
Monday. I'll get it going over the weekend. I actually had intended to get it going earlier this week, but
Well,
my judicial secretary called in sick and everything was fine. I had no problems whatsoever, but I didn't get it done. So
all right. Defendant to file an answer by, well, I'm going to give you a week to get an answer in. You're to file an answer by February 27th, 2026. And then I'll set this for an additional hearing. The way this is out, there's no reason for me to set this on a Friday. Give me a Tuesday that I can hear this.
The first Tuesday would be March 3rd.
March 3rd. I'll set this for, I'll call it a settlement conference. I don't know that that's going to happen. March 3rd, 2026 at 9 a.m. All parties are required to be present in person, including attorneys.
Thank you, Your Honor.
Thank you.
thank you, Judge.
Court calls the case of Clark Road Family Limited versus Severin Claiborne.
Good afternoon, Your Honor. Attorney Samantha Sprague, 81931, appearing on behalf of the plaintiff.
I'm present, sir. Your Honor.
Pardon?
Oh, this
didn't-
is Severin. My phone was muted. I was trying to unmute it. I said I'm present, Your Honor.
Oh, she is present.
Yeah.
Okay. All right. Where are we on this case?
Yes, Your Honor, this is a non-payment. It's a subsequent hearing. We do show that currently there is past due rent in the amount of $5,019 and court cost the amount of $239.72 for a total due owing of $5,258.72.
Okay.
How'd that happen?
I'm sorry.
When is her rent due, counsel?
Yes, her
First of the
rent-
month?
The first of the month, Your Honor, it looks like the last payment was received in November 5th of 2025 in the amount of $1,623. No rent has been received for December, January, or February.
I wrote something down very wrong. And I have to go back and look, but when we were here on the 13th,
Mm-hmm.
I think I was given a balance of 1877.92.
Give me just a moment. I do believe there was a failure to recertify that may have, let me check that real quick.
Oh, Your Honor. I
Yeah.
had went to recertify. I think did you ever receive the note, the letter that I had wrote out for you
Who?
with the dates and everything?
The note you sent me?
Yes, when I had came to turn in the last time when you had told me the paperwork like with Hawk and everything on it, and in the packet I had to fill out the paperwork and turn it into the court. I had also left a documentation of dates, and issues and stuff that I had been having, and I had submitted that in November. I had never failed to recertify anything. I went to recertify in November, and I had wrote. They just called me probably like the day before court, or it was in that week frame. But they called me and told me that my recertification was never completed, which it was completed. And I told the lady of corporate, I said I absolutely did go and complete that.
Are you
I
talking
said,
about, ma'am, when you say a note,
Yes.
are you talking about an email that was sent?
No, it was like the print off. Like I printed off along with the paperwork that I had to submit. It was something in the packet that you told me to make sure that I submitted. It was like 2 pages.
Okay, all right.
And
fine. So,
Your Honor, if I may,
yes,
I don't believe my client is on the hearing. If it's possible to get this rescheduled for 2 weeks out for an in-person, we'll confirm with my client regarding the amount and also speak with the defendant
okay,
regarding.
but, well, and let me just say this,
Wow.
counsel. My staff checked to make sure I didn't write something down wrong when a week ago. And the 1877.92 is the number you gave us
Correct, Your Honor.
as owing.
Was provided to us with the initial.
Right.
We do sometimes see that individuals lose their voucher, and I don't have any notes indicating that's what happened here. Which is why we're respectfully requesting a 2-week adjournment so we can confirm with my client that balance amount.
Ma'am, do you have any objection to the adjournment in this matter?
Well, Your Honor, can I just say two things really fast? As far as me never recertifying, that is absolutely not true. I had went to recertify in November. Yes.
I can't
Yes.
understand that I can't do anything about that because I don't know if this balance comes from that or not.
Okay, well, well, the last thing I would say, and I'll leave it at this, is they called me saying that they lost my lease at one point and asked me to come back and re-sign. And then, like I said, corporate just called me like a few days before court and told me that I had never finished my recertification, which my mama taught me to document everything when I do it and put it in writing.
Okay.
So the
I
day
hate
that I
when I'm
documented, I
speaking
still
French
have.
because apparently you're not understanding me. I can't do anything about the recertification issue until I can see what the balance is.
Okay.
I'll adjourn this matter. Well, I'm going to set it for, I understand what you're indicating, counsel. Why don't I set it for Friday? I just got to get a solid number. And then if I have to move it to a Tuesday, I'll do that.
Your Honor, I will be out of the office on the 27th. So that's fine as long as it's not next week.
Right. I was going to go to March 6th.
Yes, that's perfect.
So pardon?
I said thank you.
All right. I'll adjourn this matter March 6th, 2026 at what time?
2 p.m.
At 2 p.m. All right. Thank you.
Right.
Court calls the case of Clark Road Family Limited versus Monica Drummer.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff in this matter.
Oh, she came down in person to yell at me. Hang on. We're waiting for her to get it to the podium. Wow. Did you see it? She tried to throw something. You saw that? You gonna take her down? You got it? She's good? All right. Your name.
What you want from me?
Your name. Okay. All right. What is plaintiff's claim?
Yes, Your Honor, this is a non-payment of rent. We do show that currently there is a past due rental rate in the amount of $1,462 with court costs of $219.72 for a total due and owing of $1,681.72. We would note for the record that I was notified that the Section 8 housing voucher program has been terminated for this tenant.
Has been terminated?
Has been terminated. I'm waiting to confirm with my client whether it is terminated effective as of 3/1 or if they are retroactively applying that termination.
You know anything about that?
I just learned about it same time the complex did.
I'm sorry?
I just learned about it at the same time the complex did. I never received anything in the mail.
Did they say why it was being terminated?
My daughter and ex-husband caused my voucher to be terminated.
Pardon?
My daughter and ex-husband caused my voucher to be terminated.
Your daughters and your ex-husband or their ex-husband?
No, my ex-husband and my daughter.
Your ex-husband and your daughter?
Or our daughter, should I say.
Okay, cause your...
I just went through a messy divorce, so they attacked my Section 8.
They what?
He went after my Section 8.
Okay. Are you going to get an attorney to represent you on this?
I called, I talked to Amy last week and we talked to, was it HAP?
Yeah.
So they're working on, she's supposed to call me yesterday. I haven't heard from her.
All right.
I submitted the documents that she wanted and she's supposed to call me back. I haven't heard from her. She's supposed to call me Thursday morning at 10 o'clock and I haven't heard from her.
Okay, but at this point, we don't know when that termination is going to be effective in any event.
Well, from what they told me, it was terminated June 30th from what I was told.
June 30th.
That's what they told me. And I never knew about it. And the leasing office,
they
never told me.
Stop. But there's been payments since then.
See that I don't know.
So I don't know how that happens.
I don't know, 'cause they told me they haven't received the payment, so I don't know, Your Honor. I'm
Your
being told one thing.
March,
and this-
I'm gonna adjourn it out 2 weeks, March 6th, 2026 at 2 p.m. Let's figure out that it give you time to get an attorney if you want somebody to represent you or deal with that with regard to your voucher. All right,
All right,
thank you.
welcome.
Thank you, Your Honor. Have a good.
Okay, take care.
We did have
Westbrook
this-
Apart-
My apologies. I was just gonna let you know, we did submit a dismissal regarding the Bonita Allen. I just wanted to make sure that was off your docket.
That is correct.
It's off. It's
Thank you,
off.
Madam Clerk.
Good.
Thank you, Judge.
All right, take care. Westbrook Apartments versus Marilyn McCarthy.
Good afternoon, Your Honor. Mark Swastika appearing on behalf of plaintiff.
Is not checked in. Writ signed, issued. She filed a motion on this, right?
That's correct, Judge. So procedure, there's a default. The writ was in after a writ hearing. Ms. McCarthy failed to appear at that. Then she filed a motion either to set aside or stay the writ. One of the two. We were here last week. There was some discussion or concern regarding payments from the Ann Arbor Housing Commission and
Right.
today's date. So, I mean, I can give you an update as to what's going on, and then Your Honor can, I think I understand what's going to happen. But I guess I don't know because I don't wear the black robe.
You said, I'm sorry, you broke up on that last part.
Oh, I said, I said, I think I might understand what's going to happen here, but I don't wear the black robe. So Your Honor, tell me what will happen. But here's where we're at, Judge.
Well, yeah, if she's not here, I know there was supposed to be some checking with that. I'm gonna deny her motion and the writ can go forth.
Fair enough then, Judge.
All right. Then the defendant failing to appear, motion denied, writ may be executed.
You need me
I
to,
think I've already said it.
do you need me to submit an order to that effect, Your Honor? Or
No, that's fine. I think I had already issued the writ.
that is correct, Judge. We do have an entered writ.
So now I'm permitting it to be executed.
All right.
All right.
Very, so much.
All right, thank you.
Have a good weekend, Your Honor.
You do the same.
Thank you.
Syed Hussein versus Obey Al Ahmad.
Good afternoon, Your Honor.
There is no counsel, Your Honor. That is the defendant. I do not have the plaintiff checked in.
Well, your name
Saeed Hussein.
and your name, sir, is
Obey.
You are Obey.
El Ahmad, yes, sir.
Last time I was here, the claim, well, at the end of January, how much are you claiming is owed at this point, sir?
At this point, it's $5,590, which includes January rent, February, and also he stopped paying the water bill since last year. May of last year, he stopped paying the water bill. That's under my name, so it accumulated to $1,790.
Say how much?
$1,790.
So what's the total amount you're claiming is owed?
$5,590.
And part of that is the $1,700 water bill.
Yeah, that's included. Everything's included.
Sir, what do you have to say to that?
Yeah, so I'm in agreement with him on the 3,800 portion. The 1,700 I do owe, but that is it's stated in the lease that that's not a part of the rent itself. That's kind of a separate bill that comes in that I got to take care of, which I will take care of course. I'm not denying that claim at all. As for the 3,800, I communicated with Mr. Hussein and had asked him that, hey, I can make a weekly payment with you to take care of this full balance up until my tax return arrives, which was supposed to be the 6th of February. That was under a Act hold, which I was unaware of, as this is the first time I'm going through it, but they have released that hold and my tax return should be arriving within the next week or so, where I can take up that balance. But as for the utilities, that's a separate bill that comes in that's not included in the rent, as well as in the lease.
Usually utilities are included as part of your rent once they become past due. But
correct.
Is there a written lease?
Yes, I included it with my motion. included a lease. In the first page, it says all utilities should be paid by the tenant.
Which I'm not disputing at all. That's where maybe the miscommunication comes in. I'm responsible for that $1,790 or so change that he's claiming. Is just that that's not connected to the lease, and it
So
also
let me
states.
ask you this, sir.
Yes, sir.
When are you gonna have all of this paid? It sounds to me like you're not really disputing it. When are you gonna pay it?
Yeah, so like I said, I was supposed to get the tax return by now, and we wouldn't even be standing here. But it says by Monday is when I'm supposed to get the tax return because of the hold that was on that refund, the PATH Act hold, which I was unaware of as well. So that's why there's such a delay with everything. But I expect it within the next week. I should get it in my account. I should be able to pay him in full, which I communicated with Mr. Hussein that.
So the amount that you're claiming is owed is $5,500 or $5,590?
Yes, Your Honor.
Which one?
$5,590, Your Honor.
90?
90. That's with, without.
That didn't include your cost?
I'm sorry.
Did you include your court cost in there?
I haven't, Your Honor.
If I may say something, Your Honor, I know in the lease it says at the bottom if there's any unpaid rent, he will deduct it from the security deposit.
I'm sorry?
It says at the bottom of the lease that if there was any unpaid utilities, that he would deduct it from the security deposit. He has that in the lease.
Right, but he can't do that until you move out.
I mean, I'm willing to pay, everything. I'm trying to take care of the rent so I can get back on track with that, and then I can figure out a payment plan with the water bill department themselves by giving them a call and, figuring out paying them back. I didn't want it lumped up with the rent. That way I'm kind of having to take care of two problems at once. I just wanted to take care of his rent and then call the water department myself and maybe ask them for a payment plan or something of that nature to take care of the water bill.
Well, how come you didn't do that already?
I was waiting for this court date, Your Honor. I've been trying to communicate with Mr. Hussein this entire time, and I've asked him I can make payments, and he's kind of just ignored me.
Court finds no tribal issue. The court is going to grant a judgment to the plaintiff for possession. I'm going to include the water bill. The court, as they look at it, the water bill is due under the terms and provisions of the lease. And so the total judgment amount will be $56.91.24. I'm sorry. Yes, 24. 56.91.24. I will, sir, do this for you. The writ would normally issue on the 2nd, where you can evict him. I'm going to give him till that Friday to do that, to the March 6th. So I'll extend the time for you to get the payment in, but you'll have to pay it by March 6th. You understand that, sir?
Yes, Your Honor. Could you please repeat that a number for me, please?
$5,691.24.
Okay. Before that Friday, that first Friday of March.
Right. That doesn't include your March payment. That's
Right.
just what's due right now. All right. Thank you.
Thank you, Your Honor.
Thank you.
You'll have to submit a judgment, sir. You'll have to go up to the counter, ask them for a judgment, and you have to submit it to the court.
Okay.
Okay, thank you. Pierce Lake Village Association versus tenant. Don't know what that means. Well, tenant, and then there's James Heaton Trust and Ellen Green Living Trust. Oh, boy. Go ahead, state your names, please.
Good afternoon, Your Honor. Livia Camoro appearing on behalf of Pierce Lake Village, P85454.
Good afternoon, Your Honor. Travis Gagnon, appearing on behalf of defendants. I am co-counsel, though my formal appearance has not appeared, with my co-counsel Angela Jackson.
Got it. Okay. And this is a termination. Dare I ask, where are we on this?
So my understanding is the initial hearing was on February 13th. My colleague appeared at that. None of the defendants had appeared. Last week we were scheduled to reappear. And Angela and I stipulated to adjourn it 1 week. So this should be the first hearing on the eviction matter.
Well, there was an initial hearing on the 6th. And then the 13th. I'm not sure what happened. I didn't have a docket the 13th, did I? No, I did have a docket the 13th, and you stipulated to adjourn it.
Oh,
And
yes.
that's why we're here today. You're a week off, but I got you. All right. So now where are we on this whole case?
Well, I wasn't aware. Are you representing all defendants now?
I'm going to be representing all defendants, although I will note for the record that Ellen Green Living Trust is not an owner of the property, so an improper defendant in this case. James E. Heaton Trust owns the property, and then there is a tenant living at the property. So at least as to Ellen Green Living Trust, that should not be a defendant in the case.
Your Honor, I believe on the deed, and let me see which exhibit this would be. Yes, if you look at exhibit 1 attached to our complaint, it names it names that it was conveyed and warranted to Ellen Green Trust, which is why we named her.
Whose interest was conveyed?
James E. Heaton Trust was conveyed to the Green Trust and James E. Heaton Trust. So our understanding based on this deed, Your Honor, was that both of the trusts own the property and therefore would be responsible for the money judgment that we are requesting.
My understanding is that, again, this is a tenancy deed. My understanding is that there is not a financial interest from the other trust. I'm happy to file a formal motion, though, as it comes to striking a defendant and attach proofs and evidence in regards to that.
All right. So I'm not, I guess as we sit here right now, I'm not sure that I have the party straight. Because you're claiming that the Green Living Trust is a proper party, you're saying that it's not.
I am saying that it's not a proper party, but I'm appearing on behalf of all of the named defendants at the moment. So
okay,
I am here and everyone is represented.
All right, but we've got to figure that all out.
Yes.
All right, how would you guys like to proceed forward?
I mean, you've seen the complaint here to recovery. My understanding is that there are two complaints that they have. Again, plaintiff here is the HOA. They are not actually the property owner. They are moving for an eviction, but not necessarily possession of the property, since they are not entitled to possession. The owner here, as it goes to damages, is the James E. Heaton Trust. They are trying to evict the tenant. The items complained about are.
Have they requested that the trust evict the tenant?
Your Honor, under the Michigan Condominium Act, specifically MCL 559.212, Section 4, the condominium association has a right to move for eviction if the tenant is.
It may surprise you, I know the law. I asked a question as to whether or not they had asked the owner of the premises to evict the tenant.
Not directly, Your Honor, but they received the bylaw violation letter, which gives them 15 days to cure, and that has not been.
Okay.
Your Honor,
So that's a no?
I'm going to say that's a no, Your Honor. They have not requested eviction. They have stated that there's a damage to the outside door fixed at owner's cost, and they have said that there are multiple noise violations and that they should cure the noise violations. Our position is that the noise violations have been cured. They have not produced any police report that since this time of saying that things should be cured, or their notice to quit, that there have been any additional police reports. And I will note that in the police reports, the police did not actually find any evidence of there being noise violations. They noted that they didn't hear any noise. And there's a declination to prosecute that's in the file that was filed by plaintiff in this case. There's been no, I mean, the complaint frames it as saying there hasn't been a cure because the tenant is still there. There's been no request to evict the tenant. I don't think there's a basis to evict the tenant. And so our position here is that there is not costs owed. There's not a request for a common element to be fixed or anything like that. and there's no, there's no further noise violation, so I think it should be dismissed.
Your Honor, we respectfully disagree. Under the bylaws, there's a specific requirement that there's no noisy activity. And there have been numerous calls to the police department evidencing, and we will bring witnesses at the subsequent hearing, but I wasn't aware that that counsel was representing all of the defendants. In fact, in my communications with Ms. Jackson last Friday, she advised that she did not know whether she would be representing all of the defendants or not, and therefore hadn't contacted me since, nor filed an appearance on behalf of all defendants as of today's date. But we will bring witnesses to testify regarding the noise at the subsequent hearing.
And Your Honor, just to.
But is that going to be the basis for determination?
Yes, Your Honor, and that is appropriate under the condominium documents.
But has the noise, these people are going to come forth, say my neighbors are noisy. I'm hearing this noise. Has that been cured?
No, Your Honor, and in fact, it's loud screaming and pounding on the walls. It's not just, some loud music or something of that nature. And this happens throughout the day. And this is a problem that has disrupted the neighboring homes.
This is why normally in these cases, counsel, I realize what the condominium act indicates, that usually the owner of the premises is contacted, asked to correct the tenant's behavior and or evict. When they refuse or don't do so, then the homeowners association acts.
Your Honor, they received the same bylaw violation letter, which provides them the opportunity
Okay,
to.
all right, I know you told me this.
Correct.
I do hear, I understand, but okay. Well, I guess we're just gonna go down this road. All right, yeah, go ahead.
To contextualize, the tenant who is currently there is a relative of the owner, the trustee of the trust. There's the word that I'm looking for. I don't think that it is necessarily contested that the tenant has dealt with some mental health issues of which the family is trying to provide him services for. To the extent that they are sending cure letters to the owner to correct noise violations. Again, the curage here is any damage that has been reported, which is again just some exterior damage to the door will fix at owner's cost. Noise violations are being addressed for the procurement of treatment. I think what's being asked here is an HOA to throw out somebody with a known mental health issue onto the street because they don't like their neighbor. And frankly, we're ready to contest that.
I don't think I have an answer from you guys yet, right? How long?
Don't, frankly, I could get it by the end of today, but if you would give me till Monday, I'm happy to file the formal.
Defendants to file answer. I'm gonna make it by February 27th, 2026. And then you get that, I guess I'll reset this to the 6th. We have, correct?
You have the 6th, yeah.
Then I'll adjourn this out pending that answer to March 6th, 2026 at 2 p.m.
You're in person with you, Your Honor, correct?
Pardon?
You're in person with you?
Yes. So everybody can see how my joyous day goes. Yes, all right. Thank you.
Your Honor.
Thank you, Your Honor.
Edward Roberts versus Veronica Roberts. Hello, sir.
Sir,
Is Veronica Roberts here?
no, she's not.
All right. This is a termination.
Yes, sir.
All right. Raise your right hand. Other right hand here.
Other right hand.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And your name is Robert or Edward Roberts?
Edward Roberts, yes, sir.
Yes. And you're the owner of the premises?
Yes, sir.
On Platt Road, is that correct?
Yes, sir.
All right. And that Veronica is a tenant in some way of those premises?
Yes, sir.
All right. And who is Veronica vis-a-vis you?
Granddaughter.
Your granddaughter. Okay, so your granddaughter was living there and you wish her to vacate the premises, is that correct?
Yes, sir. She has vacated the property. She has 2 pit bulls, and one of the pit bulls attacked her little brother. And she was told to take care of the dogs, and she went to attack her grandmother, but she attacked her mother instead. So she's been, she's out of the house, but her husband keeps coming back.
Gotcha.
Every week trying to convince grandma and mom and me to let her come back.
All right. There was no written lease, is that correct?
Yes, sir. There's no written lease.
I'll grant a judgment for possession by default to the plaintiff. The writ, if necessary, to issue in 10 days by March 2nd. All right. So you have to fill out a judgment form. You have to fill out a judgment form you can get from the front counter.
Yes, sir.
Okay. And does she still have property there?
Yes, she does, sir.
Okay. So you'll fill out that form, and in 10 days, you'll have another form that you'll have to fill out, which is called the order of eviction. And then you can remove all of her property from the premises.
Yes, sir.
Okay?
Okay, thank you.
Thank you. I know I'm not gonna be able to do that. Court recalls HP foreclosures versus all occupants.
Paul Spaniel, Your Honor, on behalf of the plaintiff.
Mary Cheatham.
Counsel, how are you? I don't know how I get to the point of you saying, when I'm looking at this, that this is not a lease. Parties have all signed this. Right?
Correct, Judge. As what was sent to me, I reviewed it in anticipation of us going back on the record. It does appear that it's signed. Other than the consideration provided by Ms. Cheatham, before you as well.
The problem I've got here is that I don't think, quite frankly, that, well, I'll just say it this way, that defendant has a valid lease. And I would submit to you that the beginning of this case, because of that, this court doesn't have jurisdiction to hear this case. I won't have subject matter jurisdiction under the theory on which this case has been filed.
Subject matter jurisdiction is everything. If a court doesn't have it, the case is dead on arrival, no matter how strong the facts are. You can't fix it with arguments. You can't waive it. The judge must dismiss. That's not discretion. That's constitutional structure.
Because you filed it because of the expiration of the redemption period, but at some point a new lease entered in or new interest in property entered in, which I can see. So I don't think, there may be other reasons or a basis upon which this case could then proceed, but I can't proceed as is I don't think the court has subject matter jurisdiction. When I don't have subject matter jurisdiction over the case, then the only thing I can do is dismiss it.
I anticipated that, Judge Simpson, and I appreciate that. Would you just be inclined to dismiss it without prejudice, and we'll send out the appropriate notices today and get the ball rolling on an appropriate matter before you.
All right, very good. So like, so that dismissal is without prejudice.
And respectfully, thank you for entertaining my argument. I appreciate it.
Not a problem, sir. All
Take
right,
care,
thank
Your Honor.
you.
You and your staff have a great weekend.
You do the same. You also, Ms. Judy.
Thank you, Your Honor. You have a good day.
Court recalls the case of Arbor Woods versus Roy Williams and Terry Williams.
Rachel
Terry
Dornish,
Williams.
plaintiff.
All right, both of you are here. What are we doing on this?
Your Honor, we did have an opportunity to speak, and I believe we've reached terms for a proposed consent judgment. The total due inclusive of costs is $978.30. That balance in March and the March charges we paid as follows: $500 plus March rent on or before March 3rd, and then the remaining balance on or before March 10th. I did advise Ms. Williams of her rights under MCR 4.201J, and I believe she's given me permission to sign on her behalf. We'd ask for a default judgment with respect to Roy Williams with the same terms.
Ms. Williams, is all of that correct?
Yes.
All
Yes,
right.
I
Do
am.
you have any questions regarding any of the terms of the judgment?
No.
Well, that didn't sound too sure. Do you have any questions?
No, it's unfortunately, I just couldn't find my receipt, so it is what it is.
Okay. All right. Judgment to the plaintiffs. That is by consent in the amount requested with the terms with the writ to issue as indicated in the judgment. All right. Thank you.
Thank
Thank
you,
you
Your
guys.
Honor.
Have a great weekend.
You as well,
All
Ms.
right.
Williams.
Same.
And that's it for me, Judge. Have a great weekend.
Okay, you too.
Thank you.
Evergreen Apartments versus Kevin Sherman.
James Finkel, the plaintiff, Your Honor. Good afternoon.
Mr. Sherman.
He is not checked in. Get that all right. All right, Mr. Fink. Good afternoon. Would you like to take a default?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do. Your Honor, this is an action for non-payment of rent. This defendant, Kevin Sherman, is in arrears $1,289.52 in rent. The taxable costs are $172. We request a default judgment in the amount of $1,461.52 with a writ to issue after the statutory period. This is a possession-only judgment, Your Honor.
Judgment to the plaintiff, that is by default. For possession, redemption amount is in the amount requested with the writ to issue in 10 days.
Thank you.
And you know what I think? I think there's a sticker for this file went the same place as my staff. Because there is none.
You mean right here, Your Honor?
Just saying. All right. Court calls the case of Gulf Site Lake 1 and 2 versus BK, is it the area?
James Finkel, the plaintiff.
How you doing?
I'm doing well. Your name?
Bakai Diarra.
All right. And what are we doing?
Well, he owes $2,941.17. He applied at DHS today, but not within, well, it's today 5 days.
He's past it. Well, hold on a second. Did you pay them $1,000 today?
No, I didn't get to pay the $1,000. I'm supposed to get paid today for my job, so I was going to combine that and maybe get that in by the end of the day or tomorrow.
Okay.
Yeah, but I did call Hawk, like how you told me, and they sent me to the ozone, and they sent me a list of numbers to contact, and I applied through DHS to get the assistance, and now it's just pending.
Did Hawk give you an appointment?
No, I didn't. I don't know.
When did you call them?
This morning.
Why'd you wait so long? I mean,
Because I've been trying to catch up on certain bills and I haven't even been at home like that. So yeah, I just been trying to catch up on a lot of different things.
Your Honor, we're 5 weeks from the issuance of the summons.
I know. Sir, I'm gonna issue a judgment pending no tribal issue after a hearing for the total amount of 2941.17. And the writ would issue normally on the 2nd. I will have it issued that Friday, the 6th. So I'll give you a little bit of extra time, but you got to get it together. This doesn't include what you're gonna.
Yeah, I'm just super behind, especially, having to pay a car out of the impound and,
No,
it's been
get
a
it.
lot of stuff,
I get it, but it's
Yeah.
gonna get even worse if you don't have a roof over your head.
That's totally true.
All right. Thank you.
I understand. Thank you.
In Your Honor, I'll just say, we looked at the ledger together. Up until this case, he'd been there 18 months and had never had a case filed on him.
On him.
Which is, as the court knows, not something that everybody's able to achieve.
Right.
I hope you make it.
Yeah, thank you.
All right.
Appreciate it.
Thank you.
All right, you enjoy your day.
Court does call the case of Gulfside Lake 3 versus Latanya Powell.
James Sink for the plaintiff.
Oh, there she is. Hello.
Hello,
What's your name?
Latanya P. Powell.
All right. Where are we on this case? This is your motion.
I'm looking to see if this was a motion or a no writ without a hearing case.
I think it's a motion. I'm sure it's a motion.
I don't know that I have a motion, but she paid $538 after entry of the judgment. She's paid nothing since.
All right, what do you want to tell me? She had indicated her mother passed away. She was taking care of her mom, and then, well, why don't you tell me?
Yeah, my life just pretty much fell apart from there. I'm just started as well. I just got a job working for the post office, but I'm in training right now, so I just wanted to let you know that I was sort of working like cleaning houses, but that's not enough to pay my bills, but this job will be.
So what's her balance at this point? Because February
382109, 382109.
Have you gone to apply for assistance at all?
I asked Hawk and they said they could potentially help me if I at least pay like 800. But I feel like, they mentioned that to me before in the past and I brought it down like they told me and they did not help me. So
When was that though?
that was like last year.
Okay. So, and I mean, some of that may have been where they told you that they didn't, and then all of a sudden their funding went away. So it's not that they wouldn't do it, it's just they didn't have the funds there. When do you get paid from this job now? I mean,
With me being in training, I couldn't even tell you. Like, so yeah.
Can you move out this weekend?
If I was to do that, I was thinking next week, maybe. Oh, can I also just be transparent with you? I know my bill is looking kind of crazy and everything that I got going on. I'm also a little nervous to like accept time as well because, let's say you give me a certain amount of time and I'm still not caught up. I just would prefer to avoid eviction. Like if I have to move out, I'll gladly do that. I could be out next week. But I just really need to avoid the eviction if possible.
If you're out next week, where would you go?
That's another story. That I don't know, but that can be figured out. What I can't figure out is having eviction on my record for 7 years.
But you don't, right as we sit here now, you don't have a plan to how you're gonna be able to do it.
With my mom passing, my life fell apart. I have no idea that she was really all I had, so.
And you just haven't gotten in touch at all with Hawk.
The call that I had with them, that was it. They was like, "Maybe if you can at least pay 800 and, like that was like last week. I had talked to the landlord and that she had mentioned that to try again, because I tried with Hawk before. She said, try again. So that's what I
Did
did.
you try again or?
I had called, yeah, I called them.
Oh, that was the try again.
Yeah, that was, yeah.
All right.
Is Miss Amy online?
She is. And so here's what I'm gonna do, ma'am. You gotta have a plan in place. Right now, you don't. What worries me is you're not sure what you're doing next,
I have, no.
right?
Correct.
So here's what I'm gonna do. I'm gonna adjourn it. I'm gonna give you one more week to try to see what we can get through. So the 27th, 2026 at
2 p.m.
2 p.m. That's an in-person hearing. But what I want you to do right now, I want you to go down to the clerk's office. Can you let them know that you're gonna go into one of our rooms, get on a computer there. They'll sign you into my meeting here. And then I'm gonna put you into a breakout room with Amy, the court liaison officer, and see what resources and other things are out there for you.
Okay.
Okay?
Yep.
Do you have proof that you're employed by the post office?
Yes, I mean, I have my badge, that works.
Oh, okay. So, well, okay. I'm just saying they may, one of the things is gonna be, are you going to be able to sustain, if you stay there, are you gonna be able to sustain living there? And
As far as like, for example, like if let's say I'm working towards knocking down my balance. For me, when I'm in like actually really start the after my training days are over, I will be in the post office. I know from there I can be back ahead, but
no, I got you. I understand what you're saying.
I just don't know as far as the plan of how to get caught up.
Right. I know. That's why we're gonna try to figure that out. Okay? So go down there. They'll be waiting for you. They'll put you on a computer. We'll put you into a breakout room with Amy.
Okay.
And then we'll see you next week at 2.
Okay, thank you so much.
You're welcome. Hamilton Crossing 2 versus Veronica Whitsett.
James Smith for the plaintiff.
Hello, Miss Whitsett. How are you? I think I'm doing okay. We'll see. All right, you filed a motion. So it explains your good cause, but then
that motion either.
Right, yeah. We have an issue up front about mailing these out, getting them out.
Well, until Miss Pugh Powell gets on the job, the post office won't get it there on time anyway.
Right. Basically, she's indicating she was at work. She works with people who are ill. She didn't have anybody to relieve her with the client that she was with. All right. So how much does she owe at this point?
$23.75. She owes $17.45 on the judgment. She posted, I think, $660
today,
today.
which brought it up to 2 months rent of $11.60. So that would be, I think, 12 something. So my dilemma was I was basically living beyond my means and my finances got stretched. They cut our overtime at work. I don't know what's going on there. But they're basically overworking us, but not wanting to give us the overtime. And it put me in a bind. So now, like everything is behind. I called Hawk and they told me that I made too much money, but I have my son living with me, but they said they had to talk to him and he's in Philadelphia with his father. So they told me without him, I couldn't even make an appointment. So
That's an adult son.
The adult son, he's 25. And so when I went to my doctor's office, like I'm feeling stressed at this point. So the liaison at my doctor's office is trying to help me. But again, that's all I got as of right now. And like everything is super behind. And so I wouldn't be able to rectify it and pay it until the 7th, the balance. And that should
until the 7th
of March. And that would include March's rent. So I would be caught up totally on the 7th of March. And my rent isn't due until the 5th. So basically, if they could extend me with what I have in escrow and what I could pay on the 7th, it'll catch me completely up.
So is that the next time that you have a paycheck? Is this the 6th or 7th?
Tomorrow I get paid, but I've been off work. I had got COVID, so I was off work. So my check tomorrow isn't gonna be that much and I still have to get to work. And I have bills that come out of my check. My car note and everything comes automatically debited. So once they take that in my insurance, I'm not gonna have it tomorrow or Monday. Whenever they pay us, they've been sporadically paying us. Sometimes I get paid on Saturday and sometimes I get paid on.
But you can say that you're gonna tell me that you can pay up everything
by the 7th of March.
Let's make sure we're all talking about the same number, Your Honor.
Okay, go ahead.
So that'll be about 3,000. In how much do you have in escrow?
$660.
How would it be?
Hang on.
660.
That's all you have? You don't have anything else?
Well, hold on a second. Did you make 2 payments to escrow?
I made one today and
That's why. Okay. I was looking at that receipt, not looking at the register of actions. So I actually have 1160 in escrow. Is that right?
Yes.
Okay.
So she'll owe 2, a little less than 2 in March.
How?
Well, because March rent gets added.
To the 1735, right?
Well, right now you owe 23.75.
That's with March's rent, sweetie.
No,
it's not.
No, that's February's rent.
Your judgment was in January.
I'm confused. I'm confused now.
Okay, your judgment when it was taken. It was taken on January 30th. So it was taken right at the end of January.
Right.
So since that time, your February rent has clicked in.
Which made it 17, I thought
How much is your monthly?
my rent is 580.
The judgment was 1745.
Correct.
And I had made them a payment. I really only owed
580 plus a late fee has been added for February, so that's 630. So that took it to 2375. And add another 580 on March 1st. Late fee won't kick in until the 6th, so that'll be 28, 29.55.
Five is what I get. And so at 29.55, then if I count 1160, can you give me that? 29.55 minus 1160. 1795
Oh,
or thereabouts.
look, I guess I gotta work on it. I don't have a choice.
Hmm?
I don't have a choice. I'm way total off. I'm gonna have to get my ledger from them because it's not. Not adding up to me.
So you're, what I was gonna do is this, I was gonna release all of the escrow to the plaintiff.
Mhm.
I was gonna sign the order of eviction, but indicate that it cannot be executed till, do you get paid that Saturday?
Yes.
Okay, so that it can't be executed until March 9th.
Okay.
Oh, so I'm signing the writ though. So if it's not paid, that she's got to pay March. Part of this also is that she's got to pay March. She's got to have a zero balance. You got me?
Yes.
And I'm going to extend your time, but I'm not going to recall the writ. I'm not staying it. It's going to be out there, but understand if it's not paid on the 9th, they can show right up. They can go all the way up with the preparation of doing it.
Gotcha.
You understand me?
Yes.
Is that Mr. Moore?
Yes, it is.
I want to make sure that he understands not to.
Yes, we will make sure.
Thank
And
you.
it's you said 1735? That's what.
1785, but check with the
1785.
office because by the 9th, it'll be another 50.
Okay.
You can have that.
Oh, thank you. All righty.
You know what you need to do? Go find some money.
Yeah.
Okay.
Definitely, for sure.
Thank you, Your Honor.
Thank you. Well, and this writ needs to be prepped. And then just put on there, yeah, you can put it on there. Not to execute it for the night, but also send an email and more. All right, thank you.
Thank you.
Gulfside Lakes 3 versus Harley Argo, that matter's dismissed on plaintiff's motion without prejudice. Thank you. Who is? Miss Argo?
Yeah, I'm here.
Okay, they dismissed your case.
I
Is
know.
that all?
Yeah, I just wanted to hear you say it again.
Okay. All right.
All right. Thank you so much, Judge. You have a good weekend.
You do the same.
Thank you. Bye-bye.
BO Properties versus Cozine Welch.
April Lacy for Bill Properties, Your Honor.
They're not here. You want to take a default?
I definitely do.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. At this time, we would be requesting a default judgment for possession only where the outstanding rent to retain is $3,265, court cost of $175, total outstanding balance is $3,440. We're asking for a pay or vacate date of March 2nd, 2026.
Judgment to the plaintiff. That's by default for possession. Redemption amount, any amount requested with the petition, 10 days.
Thank you, Your Honor.
Woodview Commons versus Whitney Albright.
April Lacy for Woodview Commons, Your Honor.
Hello, what's your name?
Whitney Albright.
All right. What are we doing?
Thank you, Your Honor. I did get a chance to speak to Ms. Albright, and she's indicated to me that she'll be able to have everything paid before the end of the month. So we entered into a consent judgment, giving her until March 2nd to have the balance paid in full, which is currently $8,311.42 in past due rent, $175 in court costs, a total of $8,486.42. I did advise her of her rights under MCR 4.201 subsection J.
I was just gonna wait for Lacey to finish before I start talking. Because see, if I start
Said you
talking,
were gonna do that. You were giving
I was gonna do what?
nothing.
Was she talking? Was she talking about me?
No, never.
No, was she? See, this is what I'm talking about. It's how people get in trouble. Ma'am, you're gonna be able to get that all paid by then?
I am, yeah. Yep. I actually have taxes. They're coming back in and I showed her too the proof of it. It was all accepted. And luckily I paid a lot in, so I'm getting a decent amount back. So we're gonna be all set.
I wish that worked that way for me. I just keep.
Right?
I don't know.
Actually, I have to thank my tax person last year because I paid so much in. She's like, we're gonna take a bunch out this time and set you up. So
That way. Okay, gotcha.
Yeah.
All right. Then I will enter. Give me a judgment. Yes. All right. So you had no questions regarding any of this. Is that correct?
correct.
All right. One judgment by consent. You've been apprised of your 3-day rescission rights. All right. Very good.
Thank you.
Thank
Your
you.
Honor.
Have a good weekend. Thank you, Miss Lacy, for not saying anything real bad about me.